Um, and with that, the floor is Karen's to provide some introductions or to begin the process. Sorry.
Okay. Let me get back over to that screen. My name is Karen Winkle, and I'm the rules coordinator for the division. I will be recording today's RAC meeting, and it's more for Teddy. As a lot of information gets passed back and forth, it's just very helpful for us to have the RAC recording available. The other part that I do is I work with our web technician. We will create a web page for this particular rulemaking. So you'll be able to see today's meeting documents, all the recordings for the meetings. And so we'll get that going after this meeting finishes later this week. Thank you.
Thanks, Karen. And I just want to confirm, I think we'll do introductions before we record, or we can do them. We can start with that. But Karen, would you like to have them before or after introductions?
I've already started the recording, so
okay.
Yeah, if they can just introduce themselves and their organization, that's great.
Great, thanks. Let's start with Anton.
Hi, everyone. My name is Anton Van Seventer. I'm the Counsel for Privacy and Data Policy with the Software and Information Industry Association. Great to meet all of you.
And we'll go in alphabetical order. Ashley.
Good morning, Ashley Sutton here, Executive Director with TechNet, which encompasses Oregon, Washington, Alaska, and some of the mountain states. Good morning.
Thanks. Next, London.
Hello, everyone. I'm London Biggs, the Government Affairs Director for RELX.
Thanks, London. And just to clarify, this is the list that I'm going off of. That's with Microsoft Teams, it's bouncing around between first and last names. So that's kind of the confusion there. So Charlie Fisher is next.
Hello, Charlie Fisher, State Director with OSPIRG, we're a statewide consumer group. Hey, everybody.
Alex Chang.
Hi, everybody. Alex Chang. I'm the Deputy Administrator for the Division of Financial Regulation.
Great. Next is Chris Coughlin.
Good morning, Chris Coughlin. I'm the Policy Director with Oregon Consumer Justice.
Thanks, Chris. Next, Kate Dennison.
Hi, I'm Kate Dennison. I'm the Deputy Ledge Director for the Oregon Department of Justice.
Thanks, Kate. Derek Sangston.
Hi, everybody. I'm Derek Sangston, Policy Director and Counsel for Oregon Business and Industry.
Next is Hector Dominguez.
Hello. Yeah, I'm Hector Dominguez. I'm coordinating the work on privacy, surveillance technologies, and AI for the city of Portland.
Thanks, Hector. Next is Elise Brown.
Good morning, everybody. Elise Brown, lobbyist for TechNet.
Okay, thanks. Emery.
Good morning. My name is Emery Roan. I'm Policy Counsel with Privacy Rights Clearinghouse. We are sponsors of the California Delete Act, which is doing something a little bit similar down here in California.
Great. Felicity Slater.
Hi, I'm Felicity Slater. I am a policy fellow at Future of Privacy Forum.
Great. Haven Garber.
I'm Haven Garber. I am with the division. I am the non-depository program manager.
Thanks, Haven. And Shelley.
Good morning. I'm Shelley Greiner, and I'm the budget coordinator for the division. Thanks.
Thanks. Jeremy Hancock.
Hi, Jeremy Hancock, Government Affairs for Experian.
Thank you. Hannah Osman.
Hi, my name is Hannah Osman. I'm pronouncing her, and I'm with the Oregon Consumer Justice as a policy analyst.
Great, thanks. Next, Howard Feinberg.
Hey, Howard Feinberg. I'm with the Insights Association. We're the market research industry.
Thank you. And Jennifer Olson.
Jennifer Olson, Government Relations Strategies.
Thanks. And there's a participant showing up as info, but yeah, go ahead. info@northwestinsurance.org.
Sorry, I must have logged in wrong. This is Kenton Brine. I'm president of the Northwest Insurance Council. Thank you.
Thank you. And if there's anyone on who hasn't introduced themselves, please go ahead.
Good morning, Andrea Meyer. Meet you to the punch. I'm Andrea Meyer, Director of Government Relations, AARP, Oregon.
Okay, looks like I'm sorry. It looks like the list is much longer. So sorry about that. Just a few more.
Yeah, Pam Dixon, founder and executive director of the World Privacy Forum. We're based in Oregon. We work nationally and globally. Thank you.
Let's go with Matt Marquis.
Yeah, Matt Marquis, contract lobbyist in Oregon for Consumer Data Industry Association.
Andrea Meyer.
Andrea Meyer. I already introduced myself, Director of Government Relations, AARP, Oregon.
Bryce Newell.
Yeah, I'm Bryce Newell, faculty member at the University of Oregon in the School of Journalism and Communication.
Jesse O'Brien.
Hi, everyone. I'm Jesse O'Brien. I'm the policy manager with the division.
Peter Brown.
Good morning, everyone. Peter Brown, contract lobbyist for TechNet.
Phil Recht.
Hi, Phil Recht. I'm partner at the Mayor Brown Law Firm. We represent a coalition of people search service companies.
Rachel Emery.
Hi, everyone. Rachel Wiggins Emery, contract lobbyist for the Technology Association of Oregon.
Thank you. Richard Varn.
Yes, Richard Varn. I'm the executive director for the Coalition for Sensible Public Records Access, a public records advocacy group, nonprofit.
Great, thank you. Sarah O's.
Yes, good morning. This is Sarah O's. I'm the Director of Government Relations with the Consumer Data Industry Association, and we're the trade association that represents credit bureaus and background screening companies.
Thank you. And Ann Scholarup.
Hi, Ann Scholarup, Government Affairs for Verisk.
Great, thank you. That concludes introductions. And Karen, if you'd like to introduce yourself again.
Yes, Karen Winkle, and I'm the rules coordinator for the division. I do the technical piece of filing the rules with the Secretary of State.
Great, thanks. And I'll introduce myself. I'm Teddy Bodega. I'm a policy analyst focused on financial policy issues with the division. So thank you everybody for participating today. And with that, let's start with.
We have a hand up.
Oh, we do. Okay, go ahead, Pam.
Yes, hi, this is Pam Dixon. I just have a very brief procedural question. So there are 2 additional people from my organization who really wanted to join today, but my understanding was that it was 1 per organization. If you could clarify, that would be really great. Thank you very much.
Yes, it is. It is 1 per organization. And we do, unfortunately, to my knowledge, the additional participants, it's limited to 1 participant per recording. But if Karen wants to confirm that, I think that'd be great.
As far as sitting at what we call sitting at the table, just one per organization. That person is speaking on behalf of their organization. I can then list additional people as interested parties, and they would get all the emails that we send out in regards to this rulemaking. They just can't per se speak until at the very end of the agenda. Hopefully we have a space in there for public comment.
Great. So as we proceed, we will begin with the background of the House Bill 2052 and the scope of rulemaking. We'll then move on to the discussion of the draft rules, which were attached and included in last Thursday's email from Karen. If anyone doesn't have a copy of the draft rules, please double check your email, and also, please raise your hand. We will add it to the comment section if necessary. But after the background and the discussion of the draft rules, we'll have an opportunity for public comment, and then from there we'll conclude with a discussion of next steps to see where we go from here. So comments will be due by September 5th for this first RAC. With that, I'll go ahead and start that. With the background of this rule comes from House Bill 2052. That was a House bill introduced during the 2023 long session by the Department of Justice, and this bill was introduced by Attorney General Ellen Rosenblum, and it was developed in consultation with the Attorney General's Consumer Privacy Task Force to address the dangers data brokers pose on Oregonian safety and privacy. So businesses, large and small, collect millions of personal data points and of consumers' behavior and activities. And I think everyone on this call does know what a data broker is. But just to briefly summarize, data brokers, as outlined in the Attorney General's task force, have no direct relationship with the consumers, but do purchase information about consumers from retailers, credit card companies, public records, websites we visit, and what we click on. Here, the scope of the rulemaking here is to essentially establish the registration requirement that's in House Bill 2052. So House Bill 2052 defines a data broker as someone who collects, sells, or licenses brokered personal data to another person. And House Bill 2052 requires data brokers to register with the Department of Consumer and Business Services prior to collecting and selling or licensing brokered personal data to another person. And so with that, this rulemaking will establish the registration process that data brokers will be following. And the governor has signed the bill. It became a law, and its effective date is January 1, 2024. So the scope will, as mentioned, will establish the application requirements and the application requirements that data brokers must follow, along with the process remedies that data brokers must follow when renewing or filing or amending their registration, and fulfilling the deficiencies in the data broker registry. We will also cover the renewal of data broker registration and what process that is. The statute provides for the DCBS to collect fees, which will be collected on an annual basis. And our rulemaking today our RAC will cover the fees associated with registering. We'll also cover the rules for use of an assumed business name and the disclosure of significant developments and what information exactly data brokers will need to provide, and in what instances those that additional information will need to be provided. We'll also cover the duty data brokers have to protect the personal information that they collect. We'll also cover the investigations and examinations which the director here at DCBS may conduct in the event of to ensure securing information that the data brokers are securing information properly and efficiently. Sufficiently. So we'll also cover the termination or suspension of data broker registration and in what instances that may be the case. And the civil penalties, and lastly, the civil penalties for failing to register as a data broker. So with that, I would just like to briefly open it up to any questions, if anyone has any questions about the agenda or the scope. And hearing none, we can now have a discussion on the draft rules. And so I will share my screen, and how I envision this is we'll go effectively line by line, section by section. So okay. Here we are. And question from Pam Dixon, or did I miss that?
No, actually, that was an old hand, but I do have a question for you, but I'll wait until you finish. If there's stuff you need to say, I'll wait until you've done that. I'm so sorry.
Oh, you're perfectly fine. Let's go ahead and proceed. Okay, I think London has a question.
Yes.
Or her hand is raised. Sorry.
Thank you. I appreciate it. London from Relics again. I just wanted to, actually, it's kind of a comment. I know we're going line by line and there were no questions about the scope when you just opened it up, but I just wanted to share that some of us, only received this on, Thursday evening, and it's Monday. So I haven't heard back fully from my legal team yet. So I want to provide feedback, but just wanted to let you know that.
Great. Thanks for that heads up. I think we'll, of course, be open, accepting comments. And I think you can include additional inquiry. I'll ask for Karen to confirm that additional inquiry can be provided through a letter.
That's fine. Yeah, that's fine.
Thanks. Pam?
Yes, thank you very much. So one question I have, and this really is a question that really lingers throughout the text of the proposed language of the rulemaking. So in brokered personal data, by and large, it looks really good. It's certainly an improvement from not having a data broker registry. But I had some questions about A, but then I had a broader question as well about G. So in terms of the question about A, the question is in regards to what I would call the, the household exemption. I want to make sure that information that's recognizable at the household level is also included in brokered information, because as I wrote in comments that actually I will be submitting to you formally as comments to Oregon. The trend has been away from entities handling PII because there's a lot of liability and risk with that. So there's been a real trend toward moving to the household level for a more aggregate, but still highly identifiable analysis. So I wanted to ask you about that in regards to A, if that could be sharpened a bit to ensure that that's clear, that households are included. In regards to G, I'm requesting, and we are requesting, that analysis of brokered information is also added, because analytical and various algorithmic applications and transformations of broker data is very, very important. In the comments that we'll file with Oregon, we'll also include a report that we wrote called The Scoring of America, which we updated in our data broker filing with the Consumer Financial Protection Bureau just a few weeks ago. When data brokers have information, it's not always PII anymore. In fact, it's much less frequently PII than in the past. And while a lot of people are focused on the selling of lists, the industry has progressed far beyond that. So, for example, they may just be selling at this point scores that can be affixed to an individual or to a household level. So I just want to make sure that there's some way that analysis of data that is brokered so that it's distinguished from just any old data, but that analysis is included. So those are the two comments that I had about that. Thank you very much.
Thanks, Pam. And I think you bring up the broader discussion, the discussion on scope. I did mean to emphasize that the purpose of this rulemaking today is to implement the statutory requirements of registry and registering and what data brokers will be registering. I will provide an immediate response, and I do think that the analysis element is outside of the scope that the department has for in accordance with this rulemaking. So we don't necessarily provide analysis outside of what information data brokers will provide, and that's more of record keeping and confirmation for sufficiency. So I hope that can give an immediate response. We will of course accept your comments and we will respond accordingly. No doubt about that. So we also do have DOJ Kate Dennison on the line, and I'd open it up to ask just if there's any response there, but I think I did cover that pretty adequately. No.
Yeah, I was just going to point out that that definition tracks with what's in the statute.
Okay, thanks. And so let's go on to business entity. I did say that we will go line by line. We essentially are. So section by section, feel free, please, anyone who'd like to comment on any section. And so business entity would be in part of definition. So broadly speaking, if anyone has any other comments on definitions, please feel free to comment. Okay.
I was just going to point out that in a few places throughout there are references to both consumer and personal information. And the bill uses the terms resident individual and brokered personal information, and that was kind of by design. And so I do agree with London. I think we'll be submitting more comprehensive feedback as we have more time to look this over. But I think those were the two main things that jumped out at me. So just being consistent with the terms. And then I think in the definition of sale, that we left that out of the bill on purpose, defining the word sell. And it's only used once within the rules, so I just wasn't sure if it made sense to have that definition or not, but those were my comments.
Thank you, Kate. Let's move on then, I guess, to application requirements. If there are any comments here, please feel free. Yeah. And as I understand, it does sound like, we will of course invite comments given that the timing of the release of this. So we understand that. So okay, go ahead, Andrea.
Well, it could have been my Friday brain, but the first line, except as defined in 4A, which I believe is in the section prior, the definition section, I'm not sure I saw a 4A. So I just wanted to raise that. And I could stand corrected if I'm misreading the reference point here.
No, thank you. we'll look closer at that. And my initial look here does show that you're probably right. So thanks for thanks for catching that. And yep, we'll certainly look at that. Any other comments on application? We'll go ahead with
Maybe there's already a stigma.
Richard. Richard, go ahead.
Yeah,
Karen, I think
I
if you
just
could
want to.
mute your mic.
I did.
Oh
I
no,
did?
you're fine, Richard. But
Yeah. Okay. Sorry. Yeah. So I just want to clarify that by application requirements, you're specifically referencing in the bill, which is section 1, sub 3. So those are the places I believe you're drawing the application requirements from. When you're saying application requirements, I just want to try to coordinate these because later, Mike, you'll understand later why I'm raising this, because I believe there's a very specified set of requirements in that for the registrant to submit. And it's a very specific list there, and they have to assert 4 statements about their opt-out policy, their things. And those are the requirements you're referencing here. Is that correct?
Yes.
Okay, thank you.
And Jesse, go ahead.
Yeah, hi everyone. Just a couple of comments on this. Throughout a number of these rules we're going through are pretty similar to some other registration programs that the division has in other areas. So some of it is a little bit like what you might call boilerplate. But to the extent that we might want to adjust the approach for the data broker registry, that is something we'd be happy to take comment on. But here in the application requirements, there's one important thing I wanted to make sure that we called out, which is we do want the application here to be submitted electronically rather than on paper. And we will be using a service called My License Office, or Milo, which we're working on setting up for this functionality. That information will be defined on the department's website, as the draft here says. But we wanted to leave the rule text a little higher level, just in case at some point in the future we needed to implement a different technology for this platform, so that we wouldn't have to change the rule. So I just wanted to clarify that for folks.
Thanks, Jesse. And moving on, next is deficiencies in data broker registry application, renewal, filing, or amendment. Go ahead, Richard.
Can you just confirm for me where in the statute that it requires you to be a registered business in Oregon? Because I know that's one of the reasons you can result in automatic suspension if your business registration lapses. Could you help me connect those 2 dots, please?
Sure. I'd actually would like to defer to either Jesse or Haven to possibly speak on that.
Just to clarify, I don't think there's anything wrong with it. I just want to know if it was a requirement of this legislature. That's all.
This is Haven, and it's pretty standard for our registrations and license types to require a registration under the SOS statutes, because if you're registered here as a business, then you should be registered to do business in Oregon. And since that's a separate process, we typically require that that registration is current. The issue is that if someone fails to keep that up to date, then
I see. So they're not authorized to do business in Oregon anyway, let alone as a data broker. So
yes,
I get it. Okay, thank you.
You're welcome.
And I'll leave each section up a little bit. To give people more time to read it. Okay. We can move on to renewal. If anyone has any questions, please raise your hand. And please feel free to ask me to slow down. That's perfectly okay. So, renewal of data broker registration. All right, go ahead, Pam.
Yes, hi. Quick question for you in regards to the registration rules. They look really fine, but the question I have is in regards to some of the other data broker registries we've seen. So data brokers may not necessarily be licensed to operate in Oregon, but nevertheless, their goods and services may affect individuals within Oregon. Have you thought about that particular conundrum? Because there are really a lot of data brokers, and it's very unlikely that all of them are already registered in Oregon. There's some discussion as to what constitutes doing business in regards to broker data. So I'm just wondering if you had some thoughts about that or could clarify your thinking on that. Thank you.
Sure, thank you. It is our understanding that, well, I would ask for Haven and Jesse to comment on that. Thank you.
So I can give it a shot. I think that this is an area where we would appreciate comment from the RAC, because as maybe this goes without saying, but this is a brand new program for the department, and we do not have a large number of existing relationships with stakeholders in this space. So there may be aspects of this business that we need input into. So if there are issues around registration, either with us or with the Secretary of State, or just kind of identifying the scope of the universe of entities that we should be looking at here. This would, I don't mean this meeting, but this RAC process would be the time to bring that to our attention. And we'd appreciate any feedback in writing, anything that folks could say today, of course, and then we will likely have a follow-up meeting at some point in the future to continue the discussion here.
Thanks, Jesse. So thank you, Pam, for your question as well. And so we'll get back there on that. We're on renewal of data broker registration. We'll leave it up for a few more minutes, a little bit longer. Okay, let's look at the fees payable to the director. And here we do, this will be a non-refundable application fee or renewal fee of $600. And the fee for late renewals is $50. And this fee should be paid annually as a new registrant or also as a renewal registrant. And to assure, this fee was determined based on a fee study that the agency completed, and tracks in line with other comparable states, the other states who do have broker registrations. Excuse me one second. Thank you for that. Let's go on to the rules for use of an assumed business name. Here, in addition to any requirements for registering an assumed business name with the Secretary of State, a data broker who intends to use an assumed business name to identify the person's data broker business shall also comply with the following before doing business under the assumed business name. If the assumed business name contains words or phrases described in ORS 56.023, the data broker must obtain specific written approval from the director under ORS 705.635 and OAR 441-005-0010. The data broker must list the name as any other trade names in the application. Regardless of the lack of any ownership interest in the assumed business name, the data broker is responsible for all actions of those under the assumed business name which relate to brokering data. This does kind of coincide with the expectation that a data broker operating in Oregon would have to register with the Secretary of State. And that's kind of standard of how our registration programs operate, as you can see, in accordance with the state requirement. Seeing no questions on rules, let's go on to disclosure of significant developments. Oh, we have a hand raised, Richard.
Sure. Again, Richard Vaughn with Coalition for Sensible Public Records Access. So as I'm reading this statute, and this is important, I think, for this and later sections, looking at the requirements for registration, which, as I mentioned earlier, are in section 1 sub 3. And they're listed there. Everybody can read through those, their name, address, what your website is. And then there are 4 specific attestations you have to make about opt-out, third party being allowed to opt out for you, etc., type of information you collect. Once that information is submitted, sub 4 says you shall approve. From what I can tell, that's the end of the regulatory responsibilities of DCBS at that point. In this section, you're requiring what I think are things that are not allowed by the statute and are not relevant to those requirements for registration or renewal. And I would list those as the ones in this section would be A, B, and C. I think D is relevant, E is relevant.
Would you like me to go back up to the
No,
list?
I'm all toggling between the statute or your rules, so I can read them however you wish to show them to others. But
if you give me,
so I would say that A, B, and C imply a regulatory scheme where you have jurisdiction over the functioning of these entities and their operations. And from what I can tell from the statute, you have the authority to require them to submit an application to list this information, and then they're in a registry. And I believe your authority ends at that point. And both in this section, and we'll talk about it later, in the later section about the audits section, I believe you're actually trying to regulate and manage the operations of, or not manage, but regulate and oversee the operations of data brokers rather than managing the registry, as I think the legislature intended, because those other bills were considered during the legislative session. They were not passed. Other sort of regulatory bills. There are other bills constantly being discussed at the federal and state levels for regulating data brokers, and that's an appropriate topic for legislative discussion, we think, to have reasonable regulations. But we didn't see it in this bill. And therefore, we don't think these first 3 sections have statutory authority to be done, and we don't see the relevance to these. There may be things in the later sections, I'll say, that are relevant to someone who should be registered. But once registered, we don't see the relevance of these to any authority you've been given. Those are my comments on this section.
Thank you. And I hate to, I want to ask again, can you clarify which sections? I had to jump around there.
Sure. I was saying that A, B, and C, I don't find, and that's in the significant events part. So you're supposed to notify significant events under disclosures. So I
Okay.
think the filing for bankruptcy, I'm not quite sure how that's relevant. Data breach, which there's a substantial data breach section already in Oregon code, which covers data breach for all organizations. And it would cover everyone who's covered by this law. And there's whether the registrant receives final order from another state would imply that their behavior, their operational activities are somehow cause for or been allowed to be cause for denial of a registration. And also there's no revocation authority listed in the statute. There is, you can, if they submit the information, section 4 says they shall be registered. And that's where I think it ends. So these three, I can't see how those three relate to the requirement for a data broker to register. I understand why D is relevant, because if you're going to stop doing business, well, then you should be taken off the registry. And, you know, no, all the other requirements make no sense to take your data off and whatnot. And then any change in your assumed name, that's a really good one to have in there, we think.
Okay.
There's
yeah,
also just this broad swipe at the end to say, well, if any other material thing happens that's relevant to what you submitted in the application, that's changes, that also should be notified. So we agree with that one too. Those all seem relevant to the registration process. Did that clarify my concerns?
Yeah.
Better?
Yeah.
Thank you.
Absolutely. Yep. Thank you. And yep. Thank you. We look forward to your comments as well. And I'll ask. We'll go with Ashley next. Ashley has her hand raised.
Thanks. So yeah, I want to echo some concerns that were mentioned earlier. We did just receive these or the proposed rule on Thursday, and so I am in the process of gathering feedback from my members. So you can expect formal comments from TechNet, but at a high level, just adding on to some of their comments related to the data breach notification of 10 days. You know, there's no mention of that in the underlying bill, so that is a concern of ours. Also, in the investigations and examinations piece, that would require, you know, investigations. We would feel that, you know, our members should have the opportunity to have internal investigations to determine whether or not the nature of the incident was actually constituted as a data breach. So just, again, high level comments, and you can expect formal comments from us by September 5th.
Great. Thank you. Felicity, later.
Yeah, a question that I had here was whether any of these disclosures were going to be disclosed to consumers on the registry itself, or whether these were kind of disclosures to the department only. And one of the reasons that I raise that is because I spent some time looking at the data broker registry requirements in other states. And in both Texas and Vermont, as part of the registration process, entities are required to disclose information about breaches that they have experienced in the past year, and they're required to re-up that on an annual basis. And then that information is disclosed publicly for consumer inspection on the registry. So I was curious if that was part of the plan here, if this was kind of a separate infrastructure.
Thanks, Felicity. That is a question that we'll certainly respond to, and if available, I will ask to have Haven give any answer she can provide now, but we'll certainly, as an agency, provide an answer. Haven, is there anything you can say to that right now?
That functionality we would have to look into to see if that would be something that we would be made public based on that information. So I think we would need to research that and get back to determining what the functionality of the software is.
Thank you, Haven.
It is something we would welcome comment on from everyone involved here, of course.
Thank you. I wanted to just briefly go back to Ashley. Ashley, you mentioned there were 3 sections that you had an advisement on, and that was investigations, or 3 central issues investigations and enforcement, and data breach.
That's correct.
Okay. Is there a third one?
Those are the ones that I have in front of me at this time. Yep.
Okay. Thank you. I just wanted to ensure my comments. And next is London Biggs. Oh, hi, London.
Thank you. I appreciate that. I just want to note too, with regard to data breach and the other data broker statutes, that's actually addressed in the data broker bill itself, which is not here in the Oregon bill. So I think that's another reason for this concern, because it's not similar to the other states that have been mentioned. So there's specific data breach notification rules in those ones that pass. So I'll follow up with comment too, but just want to raise that.
Thank you. And I'll ask just that, if you guys can, those lower your hands if you can. But we can move on.
Can I don't know if you can hear
me.
me.
Oh, Phil. Oh, yeah. Sorry. Yeah.
Yeah, I think getting lost in the lower screen. Hey, just to pile on a little bit here on the data breach thing. I could be wrong, but I think the Oregon data breach law is 45 days notice. And it struck me that this is, like, as everybody else has said, it's not in the underlying statute and clearly conflicts with the 45-day notice requirement. I'm not sure it'll hold up legally, absent some authority that somebody points out that we haven't heard yet.
Thank you. Thank you for that comment. We'll look forward to hearing that.
Thank you.
Sorry if I'm bouncing around. I'm trying to keep track of hands. Is it Richard? I think
Yeah, I don't know if it helps, but I just reread that, and it's the vendors that have the 10 days. So a vendor has to notify their contracted entity, which is the covered entity, within 10 days. That's the 10 days that's in the current data breach statute in Oregon. The 45 days is the chance to notify for the covered entity, to notify the affected parties. And that is a notification that goes out. The Attorney General is also notified. There are exceptions in that section. If law enforcement is telling you not to because it'll mess with their investigation, there's other limits on when that has to be made public. But otherwise, it's 45 days as noted. The 10 days is for vendors. Now, there could be a case where a data broker is a vendor. They might be subject to that, but they're already subject to that to notify any covered entity within that time period, within that 10-day time period. So if that helps at all, something I just read. And I think for those that are concerned that this would be available to the public, everyone who's affected is required to be notified under Oregon's law. So when somebody wants to keep a scorecard and every time a data breach happens, it's not hard to do.
Thank you for that. I think it was Richard, but we'll of course as an agency provide our response and educate and advise on the law. And I saw a hand from Anton, and I'm sorry if I skipped you, Anton.
No, it's okay. I just want to echo what Richard said. That was more or less exactly what I was going to add. So thank you.
Oh, yeah, thank you. And here we have next section here is data brokers' duty to protect personal information. You see here that DOJ has a preference for the first section, the first option, but I will provide reading both for fairness. And here it shows that a data broker has a duty. We're proposing that data broker has a duty to make all reasonable efforts to secure consumers' information pursuant to ORS chapter 646A. And here's a link to that. Under this section, it would read that a data broker has a duty to protect personal identifiable information. Specifically, a data broker shall develop, implement, and maintain a comprehensive information security program that is written in one or more readily accessible parts and contains administrative, technical, and physical safeguards. I'll leave it up here for everyone to read real briefly, And I'll just, let me do some formatting here for everyone's convenience. And we are looking at this section here. So there are two options that we're kind of looking at here. So I'll give everyone a chance to review. Let's start with Ashley. Do you have a comment on this section?
Oh, I'm sorry. I meant to lower my hand.
Okay, great. Going down the list, Richard.
I have a similar type of comment on this section. I prefer A, the first one that the AG's offered. I believe it's good to cross-reference statutes in the rules, so people who are reading the rules know that they're subject to this substantial data broker breach notice requirement elsewhere in the law, as is everyone who manages PII and other data that is covered by the breach notice section. Of course, you know, every state has one of these now, and Puerto Rico and the territories all have one. And it's important to cross-reference that. When you get into the next section, as I understand that the current breach notice law has been in place for a long time, DCBS is, I think, the rulemaking entity around it. I assume you have written rules that cover everyone who's subject to that statute and that they're required to do certain things under it. And I would consider anything here that singles out data brokers as being two things beyond the scope of what the particular statute that you're writing rules for now authorizes you to do. And secondly, would be redundant, overlapping, and potentially confusing with what the authority granted under the data breach law grants you to write rules for everyone who's managing data. So unless the legislature decides to say data brokers are different under the data breach notice law, I don't think you have the authority to write the second section. And I don't think it's helpful when you're trying to manage all data breaches and all data breach notifications statewide, no matter who does it. I think that's a better approach, and we would prefer the first one, which has been recommended, rather than the or section in this area. Thank you.
Thank you. I believe Pam is next. Pam?
Yes, thank you very much. So a couple of definitional questions here and then a second question after that. So in small a, data broker duty to protect personal information, the definition of personal information is in that, but then in under the or, the small a, and then of course the one, you've got duty to protect personally identifiable information, but in the data broker statute, it had a different definition of personal information. So I think that just in general, I think that one comment I would have on the regs here, or the proposed regs, is that there really needs to be one definition so that it's just crystal clear what's being referred to. It's really difficult in the era of the kind of post GDPR to kind of, you know, make sure that it's really precise. But I think we really have to be very precise about exactly what the definition is here, because these definitions are the kinds of things that people can spend a year on. So I just think that should be tightened up. The other question that I have here is in regards to the information of children. And this gets to something that we're not discussing today, which is the data broker registration form. So really a best practice has been outlined by Vermont now for several years, quite some years now. And that is that in the registration box, data brokers are requested to note with just a check mark whether they have knowingly brokered the information of children or minors, depending on what state they're dealing with. In that case, Vermont, in this case, Oregon. If Oregon follows this procedure, which I encourage and request that they do, my question is in regards to what kind of provisions are there for the breach of information of minors? And so I just had a question about that. Thank you.
Thank you. I will ask briefly for Haven or Jesse to comment, and most certainly we'll we'll also provide a comment after this meeting. We'll also respond to your comment. Sorry.
Yeah, I would just note, I think that's a very valid area of concern, but not one that's explicitly addressed in the law that passed. And I'm not sure whether we would have the unilateral ability to request more in that area, but happy to take comment on it.
Thanks, Jesse. Sarah?
Yes, thank you, and I apologize. I'm driving in a car, so if there's background noise. Just wanted to add a couple of things. I think first, in reaction to Pam's comments, Vermont was very explicit in the law that passed on the children's thing, so I sort of agree with your take on there that that may be beyond the scope. But also wanted to echo Richard's comments on there's nothing inherent to the way data broker is defined. The definition of data broker is arbitrarily defined, which came about in Vermont, and I was instrumental in those negotiations back then. But my point here is there's nothing inherent in the way that data brokers have the information that a data breach, whether your notification needs to be different or applied in a different manner for the way that it's arbitrarily been defined in Oregon law. So I think a data breach notification for all data users should apply across the board, whether it's applying to a data broker or any other user of data.
Thank you, Sarah. So here, I think we'll I'll open it up, for more questions or comments on the duty to protect personal information. And we'll of course accept comments along with any questions as well in writing. So with that, I think here, this choice or this will be we'll flesh something out and provide a further analysis and response in what proceeds here from today. So next we have investigations and examinations by the director. And Richard, I see your hand is up, and I'll give just a little bit of time in case there are others who want to read this for now.
Should I wait?
Yeah, I think just a couple. Yeah, why not? And yeah, sure. Go ahead. Thank you.
Sure. I think this is another question of statutory authority. I think it's appropriate if you were to strike every person, strike person registered, and instead say every person required to be registered. So the editing there, I understand why this might be appropriate to find out if someone should be registered, but in fact is not registered. And you need to have some authority to go and investigate to make sure that the people that are required under Oregon law to register under the Data Broker Registry are in fact complying with the law. So I understand that part, but I don't see where any of this data is relevant to the requirements of subsection 3, section 1, subsection 3, or whether or not you can register as a data broker. I don't see this opportunity to investigate and audit the books of a registered entity, for example, other documents, records, has relevance to what is required under the statute, which is very specific. You submit the information, you answer the questions about these 4 things that are highlighted in there, you shall get a registration. And afterwards, I don't see how someone's managing their books or other things would be relevant to the registration requirement. Oh, you're going to hear me say the same thing about the termination or suspension below, but I'll wait. But you're only on this section, and I think this section is very appropriate. In some ways, you should think about what you really need to make sure someone is registering or should be. But if you take out the registered and put the ones required to be registered, I think that makes more sense. Thank you.
Yeah, thank you for your comment.
I'll just jump in for a second here to say that this is a section where a lot of this is the kind of boilerplate that I was suggesting from earlier. This is language that we use for a number of other programs. So to the extent that we might want to tailor the language more specifically to data brokers, we'd be open to comment on that. And certainly the primary purpose of any kind of investigation or examination we would be doing here would be just ensuring compliance with the statute, the registration requirements. It wouldn't be a deeper kind of fishing expedition because we wouldn't have the ability to do much with that information anyway. But we do think it's important and necessary to the integrity of the program that we have the ability to conduct those kinds of investigations.
Thanks, Jesse. Oh, I see two hands. Let's see. London, you're first.
Yes, thank you. I just wanted to say I appreciate that comment. This is one of the areas that I did flag for our legal that I haven't got a response back yet, and was concerned about just the way it was phrased, you know, investigate at any time and examine the books, accounts, records. It just felt like a very, you know, expansive part of the rule. So you can expect that we will follow up with some more specific feedback.
Great, thank you. Anton.
I would also just follow up to the comment about the boilerplate. I think that at least on our end, we would advocate more along the lines of what Richard said, and that this doesn't necessarily need to be tailored to data brokers, but it does need to be tailored to the statute itself, which whose cornerstone is registration. So it's difficult to see whether tailored to data brokers or not, how a registered entity would need to be investigated under the provisions that we see in the underlying statute. But just wanted to raise that issue too. I think it could be tailored to the statute rather than the brokerage itself. Thanks.
Thank you, Anton. Pam.
Yes, thank you. So I really appreciate this conversation. I think it's very thoughtful, and I think that it's very possible to find really good arguments on all different sides. I'm going to present a slightly different argument to you, which is this is a data broker statute, and I think it's really fair for there to be an analysis specific to data brokers. Data brokers are different in that they are a sector, and just as you would not treat health information or PHI the same way that you treat financial sector information, I think that data brokers do measure a certain amount of being able to be treated differently. Otherwise, there wouldn't be a separate statute for it. So I agree that we do need to be very careful to adhere to the language of the statute, but we also need to adhere to the spirit of the statute, which is to ensure that there's a lot of transparency and the ability to ensure that data brokers can be policed appropriately, bounded by appropriate law. So I think we have to be very careful that we don't pick apart the intent of the legislature in providing guardrails here for the people of Oregon. Thank you.
Thank you, Pam. We can, I think the questions, the comments here are pretty consistent, and of course we'll proceed with responding accordingly. So thank you for those comments, everybody. Let's look at the last couple sections, termination or suspension of data broker registration. Let's start with Richard.
This may be a familiar song, but I also want to emphasize one thing you haven't maybe discussed yet, and I'll then cover the other main point, which is that to the degree that the director needs to take records from either an entity that should be registered or look at their data, you just want to make sure you're exercising caution and aligning yourself with both your Public Records Act and confidentiality to make sure none of those records accidentally become public records that it should not be. So the investigative material might need to be clearly associated with an investigative exception that you have under the Oregon Public Records Act. Just make sure you're not breaching people's privacy accidentally in this case, because you have a right to look at the records doesn't mean the public has a right to look through you to see the records that they shouldn't see otherwise. It's one just general comment. And then specifically here, I also don't see the either statutory authority or the relevance and the scope problems when engaged in dishonest, fraudulent, or illegal practice in the conduct of business. If someone had a fraud charge against them for an ad they ran in Virginia, you say that's ground for revoking suspending their registration. Back to my point, I don't see any authority to suspend or revoke a registration in the statute if they're substantially compliant with the elements in section 1, subsection 3. And some of these, I don't see how they relate directly to the responsibility of having a registry. If someone is engaging these other practices and it's a fraud, that would be a public record in another state, and those are findable and discoverable by consumer reporting and other entities that then come back and, I mean, consumer watchdog entities. They can come back and produce reports and analysis of people that are not, you know, good to do business with, Better Business Bureau folks like that. So if your concern is protecting the consumer, we think a lot of these other components, an order by an entity or an investigation or any kind of other fraudulent activities, we think would be something that could be discovered other ways. And I don't see the relevance or the statutory authority here, as I've noted in other sections. That's my comment.
Thank you. And Pam? Your hand is up, I think.
Yes, thank you very much. We support the language as is. I think that it's really challenging for consumers to find this information. One of the things that we've really learned from the Vermont Data Broker Registry is because of how it's set up, it's been very, very helpful in learning who the players are and what information they're collecting and how it's being used. And it's really led to a lot of light and transparency in that state. And I'd really like to see the same happen for Oregon. I do think that it's quite difficult for the vast majority of busy consumers to learn about these things. I really support the existing regulation as is, because we work with these consumers and it is not so easy to find this data. Thank you.
Thank you, Pam. And thank you, Richard. Let's open it up for, okay, Charlie, go ahead.
Hi, yeah, just wanted to kind of say, at least for my read, this all looks pretty reasonable in terms of, you know, what DCBS should have access to for enforcement. So, you know, this part of it as is looks fine from our perspective.
Thank you, Charlie. And Emery?
And I think I just want to echo Pam and Charlie there. I think if you look at the California case, you know, the registry has been on the books for several years now, and we're not aware of the Attorney General being able to apply any enforcement actions for non-registration yet. So clearly there's some barriers to identifying businesses that haven't registered. Even businesses that, you know, should be low-hanging fruit because they're already registered on, for example, the Vermont Registry. And so, you know, I think that, you know, as I read these requirements, they seem fairly reasonable.
Okay, thank you, Emery. Are there any other questions or comments? Thank you. And
if I may, just briefly, I wanted to mention that we are aware that there is no specific reference in the statute to termination or suspension of a registration. So our understanding is that you know, this would be something we would be exercising under the more general rulemaking authority granted to the department in section 1, subsection 8. So rules necessary to implement the provisions of the statute here. And there can certainly be some debate about what is or is not necessary to implement this law. So we're open to different perspectives on that, but we thought that you know, this was at least a good starting place.
Thanks, Jesse.
May I respond to that? Just a bit.
Yeah,
just to,
of course.
So
of course,
that section, I read that carefully, both the section that's at the end of the regular section of the statute, section 1, and your rulemaking grant. And I read the emergency rulemaking grant, which just basically changes the timing and then the necessary. Both of them reference very specifically rules necessary to implement section 1, No other rules are listed. No other mention of authority or grant of authority is mentioned or noted there. And having been a former legislator myself, I'm always very careful when I'm drafting those things. Because I either want them to write broad rules or I don't want the agency to write broad rules. In this case, they're very narrowly tailored and targeted. Only that is necessary to implement Section 1. I understand that's some interpretation, but Section 1 is very well written and very clear in its requirements. And I do not see anything inherent that you try to claim in there is subject to a discussion about if it being extra legislative, extra legal in terms of what it does, and would be a question we might pursue more vigorously if that was done that way. So we're concerned about that because I think the legislature did a decent job of writing a registry bill to start with. And to the other issues I think that are raised, I think that's what the legislature is coming back in next time for. If you like some of these other ideas of consumer public reports about these things, that's what they're there for. They can create those kind of things as things that people can report things to, and you can find them more easily if that's what you want. But those are my comments. Thank you for letting me react.
Sure, no problem. Thank you. Kate. Oh. Hello? Looks like
Sorry,
my
I think I would also welcome the recall of others that were on the task force, but I think we always operated under the assumption that DCBS would be able to terminate or suspend a registry. I don't remember a lengthy discussion along those lines, but I think that in my mind fits into the general requirement of operating a registry. But I will follow up with my team and see if they can weigh in on that more clearly.
Great. Thank you, Kate. And I will just pause to say that I'm having Wi-Fi issues. I don't know if anyone else has a frozen. If anyone can respond, just say something if you can. But I'll have to join by phone if and if you guys can hear me, go ahead, Richard.
You seem fine.
Okay.
Yeah,
Okay. Great. I can see hands raised. Okay, things are back. Things are back. I can see everybody now. Great. London, question or hand raised. Go ahead.
Yes, thank you. So just as a participant on the AG's task force, when this bill was being discussed, to follow up on Kate's comments, I can see there being authority to terminate the registration if you don't provide what's required by the statute. But I am concerned about A and B because of how broad we just talked about in the last section about the director asking for any data or some of those requirements. Then right here, failure to cooperate during an investigation or examination can result in your termination. Failure to respond to the inquiry for the data. We don't know what kind of data they'd be asking for. So I think, that needs to be taken into consideration as well.
Great. Thank you. Pam?
Yeah, thank you. I'm just responding to Kate's comment. I was on the task force as much as I was in the country, and I remember specifically discussions about investigations and examinations by director. So I really remember those discussions, and I thought we were pretty clear that that would be included. Thank you.
Karen?
So it is 11:46, and we probably should move over to the public comments following your agenda.
Absolutely. If you don't mind, I'd like to just finish here with civil penalties. It's our last section, but thank you. Thank you for advising us all. Let's go on to civil penalties. Here we have any violation of the statute that will be researched, and any rules set forth in OAR 44830. These are temporary rule numbers we've provided will result in a civil penalty. And here we have in the amount that does not exceed $500 for each of the data broker's violation. In the case of continuing violation, in the amount of $500 for each day which violation continues, and the total amount that the department imposes may not exceed $10,000 in a calendar year. Those three are in fact are directly from the statute. But we will ask for any comments or questions. Okay, thanks everybody. Seeing none, we can now close this session or close this section of the session, and let's move on to public comment. For discussion lead, I'll ask for myself, Haven, and Jesse to be available for comment and response. And of course, we've received a good amount of public comment so far, so we are also open to any comments now. And I'll thank everybody for their patience with me because this is one of my first RAC. So I'll also ask for Karen to clarify, or Jesse, if they'd like, if there are any specific opportunities that they'd like to see the participants receive. Carly, you have a hand raised?
Yeah, I guess this is more maybe of a question, but I think that I'm curious how you're going to how you're planning on making available the registration to the public. There are a couple pieces of information in there, like how a resident can opt out of having their information sold or licensed, and some other aspects I think are important for public availability. And I'm just, ideally, I think we would advocate for something that would be proactively provided to the public, like on the DCBS website, as opposed to a public records request. But just curious if I didn't see anything in the rules about that, so just wanted to inquire as to kind of the thinking behind the implementation of that part of the law.
So Charlie, this is Haven Garber, the non-depository manager. And the way the system will work is, so it's my licensing office, which is the back office part that we use, and they have a license verification website that will be a link from our website in case the vendor ever changes. And that information would be available. So anyone in the public can search by the data broker's name. I think there's some other capabilities about searching some other information by city or so forth. And then they would see the information, the contact information on how to opt out, as well as a narrative telling the consumer what they can opt out of. So it will be available and accessible without doing a public records request is the plan.
Excellent. Thank you for that.
You're welcome.
And to echo Haven's comments, this will be, my understanding, we will provide a section in the rules that clarifies this. And I see now, Andrea.
Yeah, I just want to build on what Charlie was saying and clarify that in addition to what I think are accessed by the consumer, if I'm reading page 3 of the bill correctly, it's also what needs to be in the application from the data broker about how an individual can opt out and so on and so forth. And I just would have to relook at the draft rules, but I'm not clear that that is all delineated really clearly in the rules about what duties the brokers have in terms of providing that information in their application form. So thanks.
So Haven might want to weigh in on this, but we have developed already a draft registration form that gets at these different data elements that are required, and that will be administered through the Milo system. And typically we don't include the form itself as part of a rule unless we have to, because then it gives us more ability, more flexibility to change it around without having to reopen the rule. but we might be able to share that draft in some capacity before the next meeting. I'm not sure how far along we are in terms of getting that finalized.
This is Haven again. So we do have a paper when we weren't positive that this would be done electronically, we had a paper registration form. It will look different because we are doing an electronic format, but some of the information is similar. So we could share out what we had determined. It will just be different because of it'll be electronic. So they use different text boxes and so forth. But I'm sure we could provide something with the understanding that it would not actually be a paper form.
And this is Andrea. Can I just briefly follow up? Just to clarify, I absolutely don't want to see the form or all the language of the form, Jesse, in the rules, but I just question whether there should be some reference to the key points that are required under the statute that should be as part of the application process, and then it will be done in the form. Thanks.
Yeah, we could definitely look at that as part of the rule if people thought that that was important to have here.
Great. Emery?
I would just like to add on to all of that, that yes, I at least for an organization that has, conducted research using the data broker registries in California and Vermont, and that helps to facilitate access to that to consumers and also through our current bill. We are very interested in making sure that the registry is as accessible as possible, and would love to have the opportunity to contribute to the form that is being requested for registration, and would just also like to suggest or request that however form or shape the eventual registry takes, so that considerations may be made for accessibility and for access, being able to filter by the methods of opt-out, for example, it can be really helpful. Being able to I'm not sure, I don't believe that the statute provides for information types or anything, but to the extent possible, making it as easy to use for folks that want to opt out when possible. We would strongly support those measures.
Great, thank you, Emery. Richard?
One other thing just to consider in the interest of good government is the third parties that might end up trying to sell this service to people to opt out are probably data brokers themselves. And also just might want to consider about what protections or other thoughts you have about making sure that, people that might pretend to be legitimate third parties, because that's an easy way to get a lot of PII from someone who might be pretending to be a legitimate third party in those cases. So it's just might think about the consumer protection issues that surround that third party. We don't think they're all legitimate.
Right. Thank you, Richard. Chris?
Thank you. Yeah, I just want to echo some of the previous speakers around the importance of accessibility for individual consumers and what that looks like. So would love to see the elements that'll be part of the form, but then also some clarity around what that accessibility will be and how that will be available for consumers. So just adding my voice to that. Thank you.
Thank you. Pam?
Yes, thank you. Just to chime in on accessibility and also third parties. So quite a few individuals who have accessibility issues, and there are many, many, many online, especially visual accessibility. It's really important to allow third parties to access these services, because a lot of the accessibility processes are considered to be third parties. So I think that it's really important to keep the data broker registry available for opt-out by third parties. And I just think that going down a route that closes down accessibility and closes down opt-out solutions for people, including for people who are victims of crime, which hasn't really come up on this call, but it's a really big issue with the opt-outs. I do think that we need to keep that option open. And even if there are a very de minimis number of data brokers that are bad actors and then try to behave like that, I'd rather catch that de minimis number than close it down for the 80 to 85% of good actors who are really trying to help consumers. Thanks.
Thanks, Pam. And we are running. We're at the end of this portion. We do invite any and all comments to be included in writing. Thank you so much for everyone's participation today. We'd like Jesse, do you have anything?
Yeah, I just wanted to say I'm not sure if, sorry if this got lost in the shuffle of my calendar or something. I'm not sure whether we have scheduled a follow-up meeting yet, but we should also provide people with a deadline to provide us with written comments. That gives us a little bit of time to look at possible edits based off of those comments. Although this process is very iterative, so don't expect that what we bring to the next meeting would necessarily be the final product either, but we are going to continue working on it, and we would appreciate any and all feedback that people have.
Great, thanks, Jesse. Yep, and just to respond, September 5 is the deadline for close of business on September 5 for RAC comments, and upon receiving those, upon receiving the comments we've received today, we'll most certainly be working on editing and providing an updated version prior to the next meeting. So thanks Jesse for that reminder and inquiry. And we do have, we will be having a second RAC meeting. And I just want people to, think about now about any scheduling restrictions or preferred days. If you don't know them now, feel free to email them as well. And we're at noon, but Ashley, do you have something you want to add? Or I'm sorry if I missed you.
Yeah, I'm just taking a look at my calendar, and today is the 28th. We're heading into Labor Day weekend. I'm just wondering if we could get a bit more flexibility on that September 5th, because I know several folks are going to be out of the office late this week, and I just want to make sure that I'm able to offer robust feedback to you all.
I second that. It's a really tough deadline for this weekend. Thank you.
Thank you. I will ask, I think, was there a comment? Karen, can you provide maybe guidance on administrative rules?
You can set the feedback deadline. I don't know, maybe with the following.
Yeah, I think
would Friday,
the following.
Would Friday, September 8th work, or would Monday deadline, September 11 work for folks?
I would appreciate the 11th.
Yeah, I think.
Okay.
And I'm okay with that as well. So yeah.
And then I'll work with Teddy, if we want to do another RAC follow-up 4 weeks out. He and I will work on that with Haven, working out conflicts and such. And maybe it'll be 5 weeks out. Yeah.
So. Right. And I think, we did anticipate 2 to 3 weeks out at minimum. So it could be a little longer, but we'll give people time, and including ourselves, to kind of regroup and everything. So thank you. And so with that, thank you, everybody. I think we'll call it for today. We all really appreciate everyone's participation. So looking forward to hearing from everybody, and have a good rest of your day.
Thank you.
Thank you.
Thank you for organizing this event. Pleasure.